two undisputed facts in this case. One is that the victim was intoxicated, and two was that Mr. McCollough hit him. So I've got two different stories here. I've got the victim saying that he went into the wrong house or wrong apartment and just barely went in. And if he didn't see anyone leaving, and he's confronted, and he makes a comment to Mr. McCollough, walks away, and Mr. McCollough runs after him and punches him, knocks him. I don't think it's accurate to say down the steps, but knocked him. He fell on the steps where the photograph and the description of where the victim said he was found and the blood was found. It's, I think, maybe 4 steps from the top. And of course, Mr. McCullough's story is, and his witness's story, as much as they were ill at the same time. He came not just into the doorway, but came into the apartment. He asked him to leave. He wouldn't leave. He was not making sense. He's becomes more confrontational. He does back him out of the apartment, and then eventually he punches. He tries to get back in the apartment. He punches him, and then Mr. McCullough goes back into his apartment. Defendants are relying upon is a theory of self-defense for his give reason for his actions. I guess the concern I have is, I don't know, why Mr. McCullough just didn't, when he got him out of the apartment, just shut the door. He keeps on trying to come in, then, call the police. That's not what happened. He said he wasn't intimidated or threatened by the victim. And so, he punched him. Some of the victim's statements are not consistent about getting the ID and everything, but you've got to take into account it is uncontroverted that he suffered a concussion, and uncontroverted that he was intoxicated. And so those two things taken together could lead a person to not know where his driver's license was after he gave it to the police officer. But Ms. Akers, I think what you're asking is, to dismiss it on the basis of self-defense, and Mr. McCollough may very well have a good self-defense case. But that's something, the jury's going to have to decide. And so this is, I know the people involved, Mr. McCullough's in a position where there's more publicity maybe than would normally be, but the fact remains it's an assault case, and we hear assault cases all the time, and often there are conflicting stories about what happened in an assault case, as in this case, and as those cases, as in this case, that's going to be a question for the jury to decide who they find to be more credible, for the jury to decide whether or not, if they're instructed on self-defense, whether self-defense was appropriate on this case. So this case will be bound over to the grand jury on the same bond. Thank you. And here's everyone's exhibits. I think two, 4, 8.